Okay, so hello everyone. So this is the 15th lecture that we will be talking about today. Now, this 15th lecture basically we are trying to today I will be covering three topics, that is your treaties, formation, application, termination, then United Nations principal organs, and peaceful settlement of disputes. Right? So these are the three topics that I will be covering. I will be explaining that I always do, that what are the things that is asked in the paper. Okay, now if you look at these three topics, right, one thing is absolutely clear here is that first topic which relates to treaties, right, is basically nothing but VCLT, right. So if you look at the Vienna Convention of Law of Treaty, then in that you will find multiple chapter related to multiple concepts, right. Now those chapters need to be studied, right, as per this four thing that is given here, right, that is your application, termination, reservation, right. So these are the four things that is given in the chapter, right. So those four things has to be studied, right. So that that are the subtopic, and that is the same subtopic given in the VCLT as well. Okay, so that need to be studied, right. So that one point you should keep in mind. Second important thing that you should keep in mind is that you should talk about the meaning of reservation, right, and with respect to treaty obligation with respect to third party state, right. So there have been multiple time question that do treaty bind third party state, right. The answer is yes, the treaty bind third party state. Then how does it bind third party state? Do state need express consent to be bounded by a particular treaty third party state, or a simple binding will do? A simple declaration between two parties will do. Okay, so that concept, that what is the rights and responsibility of third party in a treaty, understood, right. Similarly, when we are talking about reservation, right, then similarly when we are talking about reservation, then how does the reservation works, right? What is the utility of the reservation? Now if you look at it, utility basically of reservation is that it introduces a sense of flexibility in international treaty, right? That suppose 7-8 countries are coming together for the purpose of concluding a treaty, right? And some country wants that, okay, I will go into that particular treaty if certain of my condition is followed, right? So reservation is a tool which is basically sort of an exception or modification that is introduced in a treaty when two countries are going for a particular treaty, understood, right? So that is the meaning of reservation, right? So you have to understand the utility of reservation and the purpose of reservation in the sense that it introduces a flexibility in international, right? So that point has to be understood, right? Then you have to talk about ratification, its mode. Now specifically you talk about ratification with respect to India, right? Most of the treaties India is ratified by the action of executive, right? But there are some treaty which requires parliamentary approval. Okay, understood, right? So what are the conditions? Okay, so that is what actually you have to see here. Okay, read here actually. Then we will come to topic number 8, and it means only these four subtopic related to topic number 7, that is your formation, application, termination, and reservation. Okay, apart from that nothing is required. Okay. Now, termination I did discuss. Termination practically means that when the treaty obligation can be waived. That is the meaning of termination, right? What are the conditions under which the treaty obligation can be waived? Okay, that is the meaning of termination. Understood that particular point? Okay, so you should know that what are the treaty obligation under which termination can be done, right? Obligation can be waived, termination can be done. Okay, so that is one point you should keep in mind. Then you come to the recent criticism of the treaty provisions and how it have been undermined in the recent times, right? You give some of the example, Indo-Pakistan treaty with respect to Indus, right? So that have been under considerable lot of pain, right? Lot of pain meaning, both the country are blaming each other that you are not following the treaty provisions. Okay, now as a general also treaty are not being followed around the world, right? So that is one point you can actually very philosophical type, that treaties, even if it is a part of very important and very important source of international law, but still people sometimes avoid following the treaty, right? So in that sense you have to study the treaty. Okay, then we will come to the United Nations. Now United Nations, the topic is principal organ, power, function, and reform, right? So these are the three things, right? Principal organs, power and function, and reform, right? Power and function sometimes go hand in hand, right? And reform is basically with respect to India. When we are talking about reform, power, and function, then you remember only two organizations is important for the purpose of power, function, and reform. One is the Security Council and second is General Assembly. Right? Now General Assembly need not multiple reform. Why? Because it truly it possesses democratic character. But most of the reform that we are talking about is with respect to Security Council. Right? So that is one point that you should keep in mind. Right? So focus on reform. Right? Put out the India, read the India's point of view. In fact, I will suggest you go to the UN website, and there we have reform.un.org. reform.un.org, right? So all the issue related to reform, contemporary issue is present there, right? So go and simply read it, and that will suffice actually. That will be more than sufficient. Understood that particular point? Clear? Yes. So keep that in mind. Then go to the bare text of the organization, right? The bare charter and UN charter. Now go to the UN charter and read Article 1 and Article 2, right? Purpose and principle. Understood, right? Simply read the line by line provision of purpose and principle, because they are directly asked in exam. Okay, what are the major purpose of the principle of United Nations, right? You simply write the article, Article 1, Clause A, Clause B, Clause C, Clause C, something like that. Okay, that will be more than sufficient. Okay, then then read power and function structure of each organization, but mostly focus on two that I told you, that is your General Assembly and Security Council. Actually it is mainly Security Council, okay, United Nations Security Council, right? But also talk about normally working of UN, in the sense that these two have been a very important instrumental body, but still United Nations Economic and Social Council, right, ECOSOC, they have performed a very vital function in United Nations in making it more humanitarian organization, right? So in that sense also it has to be studied. It is a more humanitarian organization than other organizations. Understood that particular point, right? So that sense also has to be studied, and you should actually try to read it. Okay. Then working of UN, its criticism, that how far it have been able to achieve its objective, right, or its principle or purpose, right? Now, I mean, no matter what the people say, but one thing is very clear, that it is a post World War organization, right? And it have been able to prevent any major world war. I mean, there are multiple failure, but more or less take a very positive attitude. Yes, they have more or less followed, right? More or less followed the charter, and more or less it is, I mean, they have done good for the organization, right? So that particular point you keep in mind. Okay, so that will be all for topic number 7, that is your related to United Nations, right? There are multiple other topics also we will discuss later on. Then we will come to the peaceful settlement of dispute, right? Now their word is peaceful settlement. Remember, there are two types of settlement. One is the peaceful and other is forceful settlement, right? So forceful settlement includes basically war, embargo, multiple other methods, right? But peaceful settlement only consists of ADR mechanism that we have in India as well, right? Conciliation, arbitration, mediation, use of good offices by the UN, right? Similarly, you can talk about ICJ, judicial settlement is also one of the principal, very important process of peaceful settlement of dispute, right? Their relative merit, their relative demerit, okay? So that also has to be understood, right? Merit and demerit, okay? Like, what is the merit of a judicial settlement? The merit is that it is very calm process. Each and every process is identifiable. Okay, this process is going to happen. But in the case of arbitration, the arbitration award might be totally secret. Okay, so it is not so open. But what is the benefit of arbitration? When it is secret, then both the party can come together with a solution which they don't want to make it public, right? Like today India and China will want arbitration. Why? Because no one wants to acknowledge that my soldiers, number of soldiers have been killed more. Understood? Like China haven't even acknowledged also, right? So that is one point actually I am talking about, that arbitration is sometimes much better. Okay, much better. Similarly, that is the in the H also I have written the same thing. Read individual detail, like what scenario they are useful or what it lacks. Okay, means the relative merit and demerit. Okay, so you can simply. So that is very smaller topic actually, right? So 7, 8, and 9. Now, with respect to some of the important case laws I have given you here, notes. One is the meaning of treaty, right? So if you look at the Article 2 of the Vienna Convention, actually defines treaty. What does it say? A treaty is an agreement whereby two or more states establish or seek to establish a relationship between them governed by international law, right? So this definition is very interesting definition, in the sense that it talks about treaty between agreement between two or more states. It means you do not consider non-governmental international organization as something that can go to a treaty. Okay, so the treaty according to it will only be by states, sovereign states, right? So they are talking about treaty only between sovereign states, but there are multiple type of treaty called treaty contracts that happens between multinational companies and the government. Okay, so that it does not talk about, so that is lacks actually, right? Then if you talk about the obligation of third party, right? So here very interesting point that you have to understand, given in Vienna Convention 35, Okay, when treaty imposes some obligation on third party and it accepts that obligation in writing, then such a party is responsible or bound by that particular treaty, right? So it means that ordinarily speaking, treaty cannot bind a third party state unless third party accepts it, right? Unless third party accepts it in writing. That is the main point. In writing. Okay, so there has to be express consent from third party, right? So that is the crux of the responsibility of third party. However, by the rule of equity and good conscience also, there is a concept according to which that if you are enjoying the benefit of a treaty which you are not a part of, and when the time comes to pay, then you cannot say that I cannot pay, right? So if you have enjoyed the benefit of a two-party treaty, right, so there is an indirect consent, right? So in that case, even if it is not in writing, you will have to be responsible. I mean, there is an obligation on your side as well. Okay, that privity of contract concept will be not valid here. Okay, so that is one of the point. Okay, now again I have very briefly told you these two concepts. I will suggest you to read in more detail. Okay, now let us come to aims and objectives. So what I have done actually, that I have actually written aims and objective, right, just as given in international charter, right? Prevent a scourge of war, right? So if there is any question which talks about that whether the UN have, I mean, what is the importance of UN in protecting the war, right? So you can cite that the very aims and objective of the UN suggest, first line, you simply write down, to save succeeding generation from the scourge of war, right? So these all principles shall be used for the purpose of supporting any question which requires philosophical argument saying that UN have done this, UN have done that. Okay, so you should by heart remember the objective, principle and the preamble of United Nations Charter. Okay, so at least have a read about it. Okay, that makes your answer look very good actually, right? So that is one thing, right? To promote the maintain international peace and security. Right? Multiple times they have been discuss the role of UN in maintaining international peace of security, or discuss the role of Security Council in maintaining international peace and security, right? So in those cases you can simply cite this particular line. Okay, then if you look at the preamble, that article 2 provides for the principle, right? So article 1 is the purpose, article 2 is the principle. I mean, both are different things, but the message is actually same, right? See here, sovereign equality to all its members, right? So United Nations recognizes sovereignty indirectly, right? So if a person, I mean, if a territory becomes the part of UN, it means automatically it is a sovereign nation, right? So one of the method of recognition, collective recognition of a particular state is basically its admission to the United Nations. Okay, so that is one thing that you can cite in the recognition topic. Then member states shall in full faith obligate themselves settle dispute by peaceful means. Again, any question related to peaceful settlement of the dispute, you should remember then the UN Charter itself, there is a specific chapter devoted to peaceful settlement of dispute. Okay, and you can cite preamble along with it, right? Similarly, not to use force, right? Now there is a specific topic, topic number 9 or 10, I suppose, which talks about the use of force, right? International law justifies use of force or not, right? So there, very important point here is that member states are not threatened to use force. It means if you will not, start to threaten the use of force, right? But you can respond with the use of force. Okay, but you should not be aggressor, but you can be defender, and while doing so, you can exercise your force. Okay, so that is the primary point here, right? So remember it. All member states to assist preventive and enforcement action against state, and that is talking about that if a Security Council passes a resolution against a particular state, right? So that state should take effective measure to stop it. I mean, all other states should take effective measure to assist Security Council in enforcing such resolution. Okay, so that is the one point. Okay, similarly, non-member states act in the accordance with these principles so far as necessary for maintenance of international peace and security, right? So that is something very interesting, that the United Nations Charter says that, okay, even if you are not a member of United Nations, still you may be governed by the principle of United Nations, okay, non-member states. However, that is not the case. There is, I mean, not multiple member who is a non-member of UN, obviously. Now, peaceful settlement of dispute, I have already talked about these 4 methods, right? See, arbitration, judicial settlement, negotiation, settlement under the auspices of United Nations organization, that is mainly ICJ. There is Security Council, they also settle dispute, right? And there is a Office of Good Offices, that is already written here, I suppose, yes. Good Office of the United Nations. Good Office is basically people who are specifically appointed by United Nations to solve a particular problem. I mean, good people, right? The people who both can trust, who can act as a mediator or conciliator. Okay, so that is the office, Good Office of the United Nations, right? Passed as a consequence of the UN General Assembly. There was a resolution, I think in 1978. You check it once. I do not remember it clearly. Okay, right. Now, one important thing is that what is the purpose of the settlement of the dispute, right? Why we try to settle a dispute, right? So either to prevent further breach of peace, act as a deterrence, restoration, rehabilitation, okay, reconstruction. Okay, so if a person, a country have been destroyed by your act, right? So that act need to be, such a way that whatever the wrong that have been committed to that particular country has to be restored. Mostly the humanitarian basis, right? Mostly it is the humanitarian basis. Okay, so that one thing you remember, right? So apart from that, I don't think anything is required. Okay. Now let us look at some of the previous year paper. Enumerate the various method of peaceful settlement. Elaborate judicial. How basic question this is, right? Too basic actually. Right? It's too basic question, right? So if you are not able to do this question, I think very bad, very bad situation is there. Then arbitration is the most effective way. Discuss the advantage and disadvantage of the arbitration. Okay, so you have to explain the arbitration, how it is more useful, and then advantage and disadvantage, right? Again, a very straightforward question. Ratification of treaty, right? Also examining the consequences of non-ratification, right? So obviously non-ratification always doesn't mean there's a topic of formation of treaty. In that formation, sub part is ratification, right? So treaty starts from negotiation and ends with ratification and then enforcement of the treaty, right? So there are 6 steps actually in a treaty formation. Okay, so it is talking about the last step, right? Ratification of treaty. Okay, discuss the provision related to amendment and modification of treaty under VCLT, right? Separate chapter in the VCLT about amendment and modification. Similarly, while concluding multilateral treaty, a state can make reservation, may accept or reject such reservation without jeoparding the object and the integrity of the treaty. Discuss the need and relevance of reservation in the treaty law in the light of above statement. See, in the case of reservation, I told you they are unilateral statement which a state give for the purpose of modifying treaty provision in their application on them, right? That is a reservation thing, right? Now, one of the important thing about reservation, that reservation cannot be against the primary object of the treaty. For an example, if the treaty is for the purpose of governing trade relationship, now I go to I as a sovereign state go to that particular treaty, right, and say that okay, I will accept that treaty on the reservation that I can do whatever I want, right? Now if you could do whatever you want, then what is the purpose of the treaty itself, right? It is irrelevant. Okay, so the treaty object, the reservation should be such that it should not be against the object of the treaty. The object of the treaty is to govern, to rationalize your behavior, and you are saying that I will be doing whatever I want. So obviously that cannot be allowed. Okay, understood? So that is the point actually you have to write here. Understood? Okay. Now I used to give questions and check some of the questions, but that I am not doing it, right? The reason because I am not taking this live, it will only go on YouTube, as de facto IS have instructed me that I think there is some cost attached to that that Zoom, right? Zoom used to be paid version or something like that. They told me something, I don't know, right? But I have told them that at least you complete their syllabus and at least put it up on YouTube. Okay, so it will be on YouTube and you question it. If you have any question, you do ask me. Okay, all of you I think have my mail or by default. Okay, so that will be all. Thank you very much.